Hi, this is Curt and welcome to another edition of Fire Law Roundup.
So we got 5 good cases. Some are short, some are longer. One you're going to handle on FLSA, which is right up your alley, and I thought was very interesting. But let's start now. We're in the 7th Circuit. What state is this in? I'm actually not even sure.
Illinois, Kankakee, Illinois.
Okay, perfect.
Yep.
Here, this is really interesting. So we have and by the way, as you're listening to this is more a lesson on how lawyers plead and challenge actions rather than I can't believe the person lost. So you'll see what I mean in a minute. So we have a situation where firefighters go to a fire, active fire at, I think, a nursing home or some sort of elderly resident. So the chief or the incident commander tells a female firefighter, Michelle Geis, or however it's pronounced, but tells the female firefighter and the crew, listen, take a charge line into the building, wait till it's charged. And in the interim, they then anyway proceed into the building with a uncharged line, claiming they didn't hear the orders of the incident commander. I think they're the incident commander, but
it was a lieutenant. It was a company officer. So the company officer told the firefighters, stretch the hose line, but don't advance in. It's actually a senior citizen, as I understand, a senior citizen center building, senior living facility. Sure. So you got a residential facility. Yep. Probably high occupancy, but he says don't proceed in until the line is charged.
Right. And whether people agree with that is not this issue. Right. I would have gone in with a non-charged line, but it doesn't matter. And not this issue. So they apparently don't hear that instruction. They are using a camera, a thermal imager. They determine that the fire is contained to a room and they start advancing down the hallway. As they start advancing with an uncharged line in contravention to the order that they allegedly did not hear, as they start advancing down, they hear some moaning of a resident. They open the door and they start to extricate the resident who was actually burned. At that time, this lieutenant / incident commander, I think it's the incident commander, but
he is the initial incident commander, correct?
Right. So and the reason I say that, it gets confusing because that person then goes inside the building as well. And where this now happens. So that individual who gave that order now goes into the building, sees them having stretched the hose line uncharged in contravention to the order they allegedly did not hear, and physically assaults, I'll describe it, but physically assaults that female firefighter by this isn't allegedly, this is what the court found the facts to be. And by the way, I should back up. This is a decision of a court, and the court has found these facts to be the facts. So this is not me saying allegedly, right? Mm-hmm. This is what the court found, and it's important. So the court finds that the lieutenant picks up the female firefighter, slams her off her feet. I guess this must be a big guy or a small woman, but picks her up, which is not easy to do with SCBA, et cetera, on slamming her against the wall a couple of times. So there's now the individual after, and the person was very angry, but the individual after, understandably, some PTSD and other issues having as a result of this, she sues, as you would imagine, right? And what she sued under is what's important to this case. So she sues and loses at a federal appeals court, is about as high as this is ever going to go. And let me tell you what they didn't sue under. What they did not sue under, as far as we know, is a state level assault case, right? You physically assaulted me. And one of the reasons they may not have sued for assault is because during assault from an employee to an employee, unless there's an allegation of negligent hiring where you knew the person was violent or something, it's the employer or the fire department is not going to be liable for the assault of one employee to another because they're acting outside the scope of their duties. Their duties isn't to assault someone. So here, and the court kind of makes reference to it in about 3 words, that this shouldn't have been a federal action. Maybe there's an action in state court. I think that's what they're referring to. Mm-hmm. And so, but But normally assault, you get 1 year, some states maybe 2 years to sue. This would have been sued already, right? Because this happened in 18. So leaving the assault case, because that's not this. This is not a pure assault and battery case. What this case asserted was that the department had a practice of retaliating and silencing and allowing these types of incidents to occur, because the person who was assaulted not only was assaulted, but also complained about it. An investigation happened. There was some minimal punishment. I got to tell you that punishment looked pretty minimal for the actions taken. I was a little shocked. But nonetheless, they lose because they sued under a Monell claim, which says, and I've had a couple of these in court, which says, and I have one now in court, which says that the department, the employer, has a practice, either unwritten or written, usually it's unwritten, of doing something that's so widespread that they actually encourage it, right? That they tolerate it. But here they lost, the court says, because one, everybody claimed they were shocked at the lieutenant's physical assault. So that shows there wasn't a practice or a policy of allowing it. Nobody knew this person did it. And they couldn't prove that there was any widespread written or unwritten policy or practice that would have allowed the retaliation or the assault. So they lost. And I get it. I that's a very tough case to show that we're just going to allow retaliation. In gender discrimination, I could see, but usually you see Monell cases come up when you say we have a practice of discriminating against race or gender, right? That's your typical Monell case. This is for assault and retaliation, et cetera. It is a very tough case to win, and they lost. But again, this is the court saying, maybe you should have gone towards just an assault case. I would have. That he's, if they're a paid firefighter, they got money.
This is a stretch. Let's face it. She's the allegation. And this is what happens. You have a client. The attorney has a client. You feel like something is not right. What are you going to sue under? And here they went under the Fourth Amendment. They alleged there was a seizure of her. So by the lieutenant grabbing her. And again, while the court found these facts, I tend to think the facts are disputed. And the reason I tend to think the facts are disputed is the lieutenant only got 24 hours off, which we know. I mean, the average person thinks 24 hours off is 3 days off. It's 1 day off. He got one shift off. Okay. Right. So that, to me, I can't imagine a chief is going to condone physical violence in the workplace. That's usually a terminable offense. So therefore, the fact he only got 1 day off, it could be looked at as condoning it, but I think maybe the facts aren't quite as bad as the allegations are. Okay. But be that as it may, you still shouldn't go hands-on with a subordinate. Absolutely, positively shouldn't. Okay. So they're alleging that it was a seizure, a Fourth Amendment seizure. I think that's really a stretch. And the court they have sympathy for her, but they're saying this is not a Fourth Amendment issue. And then you flip over to the retaliation side, and there just wasn't a connection between what she alleges was an adverse action against her and the triggering event, which was either reporting the assault or complaining to the EEOC. There was some factual questions about exactly where it was. But I do want to talk about why the attorney might not have gone after him, the lieutenant, which probably should have, but or the department. And the most obvious one is, like you suggest, the assault, or there could be intentional infliction of severe emotional distress, or
maybe the time expired by the time she went and got an attorney.
Right. And so that may be one of the things. But number one, I see two things, and you kind of summarized it in that it may have been outside the scope. An intentional act like this would be outside the scope of employment. That's a good defense. Okay. But I think there's two strong defenses that the fire department had, or would have, if they had pursued that. And number one is immunity protection. Okay, that It's a governmental function. This is sort of what, whether a supervisor yells at you and there's a factual question, pushes you or lifts you up or whatever. Be that as it may. You've got this sovereign immunity or maybe statutory immunity protection. Okay. And I think that's sort of, as a plaintiff's attorney, you've got to say, all right, I got to somehow get over that. The second one, and probably the one that's more difficult, is going to be the workers' comp exclusivity immunity. And, there are some exceptions here and there. Some states give more than others. But I think, when you're at work and you get hurt at work, your exclusive remedy is workers' comp.
As against the employer.
As against the employer, but no, even coworkers. Yeah, there's cases. Yeah, there's an interesting
the coworkers acting outside his scope of duty, so it's not a covered.
And again, there's some state by state differences there. But there was a case. The case I think I used in my book was you have a volunteer firefighter who is at the scene of a fire, and a second volunteer firefighter comes driving up and smashes into the back of him. And he wanted to sue the other firefighter who hit him. And the court said, no, that that's a coworker, and regardless. And then there was some question, was it reckless? Was it grossly negligent? And pretty much the court said, no, I mean, you're at work and things that happen at work are covered by workers' comp and yada, yada, yada. Now, it's different if a third party came up and ran a firefighter over. Just like here, it'd be different if a third party assaulted a firefighter. But in terms of the workplace, when you're at work and things happen, your exclusive remedy is workers' comp. So I think between those two, sovereign immunity, workers' comp, and maybe, as you suggest too, the scope of employment, those probably cause the plaintiff's attorney to say, let's go after a constitutional claim, we'll make a Monell claim, and the court just didn't buy it.